Hey, good afternoon to you. 306 here at News Talk 105.9 WMAL, where we are making sense of the news. Coming up today, Will Chamberlain is with us from the Internet Accountability Project, Article 3 Project. We talk about what's happening in Georgia and why Fani Willis needs to be charged with perjury. More on that ahead. David Strom joins us from Hot Air at 4 o'clock. Julie Kelly is here at 4:30. A lot to get into. Dr. Stanley Goldfarb, that is from Do No Harm, talks to us about the chaos DEI is causing in the medical industry. That's at 5 o'clock. And Greg Murphy, the congressman, also joining us then. And you can join us, as always, at 888-630-9625, 888-630-WMAL. In just the last few minutes, news breaking that the Lone Star State will be able to arrest and deport illegal immigrants, at least for now. Texas can seize illegal aliens. We'll see what they do with it beginning this evening. But the United States Supreme Court, according to the New York Times coverage of this, will not block, for now, a, quote, aggressive Texas immigration law. Let me change it. A sensible Texas immigration law will not be blocked, at least for now. And here's what they're saying. The Supreme Court temporarily sided with Texas on Tuesday in its increasingly bitter fight with the Biden administration over immigration policy, allowing an expansive state law to go into effect that makes it a crime for migrants to enter Texas without authorization. As is typical when the court acts on emergency applications, its order gave no reasons. But Justice Amy Coney Barrett, joined by Justice Brett Kavanaugh, filed a concurring opinion that seemed to express the majority's bottom line. They were returning the case to an appeals court for a prompt ruling on whether the law should be paused while an appeal moves forward. Justice Barrett wrote, quote, if a decision does not issue soon, she wrote, the applicants may return to this court. The three liberal members of the court, Justices Ketanji Brown Jackson, who doesn't know what a woman is and thinks the First Amendment is designed to protect the federal government, Elena Kagan and Sonia Sotomayor all dissented, obviously, because to them, everything's political. Quote, today, the court invites further chaos and crisis in immigration enforcement, Justice Sotomayor wrote, which is the exact opposite of the truth, allowing additional law enforcement personnel to enforce the laws that are already on the books is not a way to create chaos. It's a way to bring about peace. She says, we're going to have further chaos and crisis in immigration enforcement. Ask the Border Patrol guys what they think of this case, of this law in Texas. Ask them. What do they think? Oh, they like it. They appreciate it. Texas passed a law, she continues, that directly regulates the entry and removal of non-citizens, illegal aliens, and explicitly instructs its state courts to disregard any ongoing federal immigration proceedings. That law upends the federal-state balance of power that has existed for over a century, in which the national government has had exclusive authority over entry and removal of non-citizens. Just so the justice is clear, so she knows. I don't know if she knows this, so I'll tell her. It is illegal to come into the United States without authorization. It is illegal. The federal government says so. So all Texas is doing is saying, we honor federal law. We are upholding what Congress has already put on the books, signed into law by the President of the United States. You can't come here illegally. You can't. The lefty justice is upset today about this. The court's order addressed just one aspect of the clashes between the White House and Governor Greg Abbott of Texas, who has embarked on a multi-billion-dollar campaign to deter migrants, including by installing razor wire along the banks of the Rio Grande and a barrier of buoys in the river. The surge in migrants entering the United States has intensified a fraught battle over immigration policy, underscoring deep divisions between and sometimes within political parties. It has led to the impeachment by House Republicans of the Homeland Security Secretary and the failure of a bipartisan Senate deal to increase border security, says the New York Times. Of course, the New York Times is wrong about that as well. They're misleading you. The bill would introduce amnesty. It would accelerate work permits for foreign nationals who invade our country. It would give a bailout to the cities who treat illegal aliens as if they are entitled to be there. Sanctuary cities would receive a bailout in this bill. The entire bill was designed to encourage the very type of invasion that we're now suffering and exacerbate the problem. So it wouldn't, quote, increase border security. For every Republican who opposed it, thank you. Thank you for stopping that. It would have made things worse. The law in Texas, the New York Times continues, sometimes called SB 4, that would be Senate Bill 4, empowers state courts to order the deportation of migrants who enter the state without authorization and gives local law enforcement the authority to arrest those who cross the southern border unlawfully. The administration, civil rights groups in El Paso County challenged the law, saying it interfered with the federal government's power to set immigration policy and to conduct foreign affairs. You know what's useful about this battle? I mean, obviously you want to see Texas prevail here because at least somebody's on the side of sanity. But one of the useful things about the public fight that's happening right here, if you were to talk to the average person who doesn't follow all of this very closely, you say, okay, what is the Biden administration fighting for? For illegals to stay in our country. What is Texas fighting for? A secure border. Why is the Biden administration fighting against a secure border? Why? Well, it's worse than that. They're not just fighting against a secure border. They're actually working to destroy that border. Remember? They've been cutting through the barricades that Texas has been setting up to allow more people to pour into the country. They've begun using an app. They've established this CBP One app to allow people to come into the country like they're ordering Uber Eats. They just enter, what country would you like to go to? America. How soon would you like to be delivered? Now. No fees. It's better than Amazon Prime. You're there in a second. You can do that on the app. And they bring you into the country. And then they can say, well, you didn't illegally migrate. You didn't get here illegally. We brought you in because you came in on the app. And therefore, it's better? Is that what we're supposed to be told? And meanwhile, 90%, huge numbers of the people who claim, quote, asylum aren't actually entitled to it. It just takes years to make that determination. And by that point, it's too late. They've already have children. They've already set up an entire thing. They probably have businesses. They're in the schools. They're everywhere. It's all interconnected. It's impossible to untangle. The governed were never consented. The governed never gave their consent to this. That's it. And so that's what we're dealing with. We've got a massive illegal immigration problem. Let's see what happens here. Let's hope that Texas can actually do something with this. Let's see. But right now, the big news today, at least for now, the Supreme Court getting out of Texas's way, saying you are free to carry out the law as written. While you litigate this thing, you can take people into custody. You can begin deporting them. Let's do it. And every other state, by the way, every other state, and I know Florida, I know there's been some states who have been sending in law enforcement to help. If with whatever you're capable of doing, please help. Please. Send the National Guard, send the police, send whoever needs to be out there. Help secure our border. It's the number one issue among Americans. Number one is getting control of the border, getting control of our sovereignty. And our federal government's not going to do it. They're actively working against us. They're in league with the cartels. But for the rest of us, for the sane among us, this is a victory today. So at least for now. And now, in the midst of all this, you have judges who are still making insane rulings. You see, a federal judge in Illinois has found that the Constitution protects the gun rights of illegal aliens. The gun rights of illegal aliens. The Constitution. So if you come here illegally, you're a foreign national. If you invade our country, you are entitled to have a gun. That's the judge today. A federal judge in Illinois has found that the Constitution protects the gun rights of non-citizens who enter the United States illegally. U.S. District Judge Sharon Johnson Coleman, this past week on Friday, ruled that a federal prohibition on illegal immigrants owning firearms is unconstitutional, as applied to defendant Heriberto Carvajal Flores. The court found that while the federal ban is facially constitutional, there is no historical tradition of firearm regulation that permits the government to deprive a non-citizen who has never been convicted of a violent crime from exercising his Second Amendment rights. Quote, the non-citizen possession statute violates the Second Amendment as applied to Carvajal Flores, the judge wrote. Thus, the court grants Carvajal Flores' motion to dismiss. Okay, So the illegals can own guns. But you know who can't own guns? American criminals. That's right. In the United States, if you are a felon, you are not allowed to own a gun. But if you illegally immigrate into the United States, this judge just said, you're fine. You can own a gun. So how is it that an illegal alien, let's just say, let's say you can conclude that they have constitutional protections. How is it that an illegal alien is better protected than an American criminal? The first thing you do coming into the country is commit a crime, and you're entitled to everything. Welcome aboard. You get to own a gun. American felons? No, not for you. Not for you. So that's the chaos we're dealing with this week. And, we'll see. We'll see what these judges do here. But it's in the midst of this, we've got like, I'm telling you, I can't tell you the number of headlines I'm seeing each day about the latest illegal alien who's committed some deranged crime, and we're supposed to just live with this, and we're supposed, and the Biden administration is aiding and abetting all of it. We've got a report here, Daily Caller headline today: report illegal migrant church teacher accused of molesting young girls was deported twice before, and this story, unfortunately for our audience, is local. This is a local story. An illegal migrant from El Salvador, charged with molesting young girls March 11th, was deported from the United States twice before the alleged molestations, according to the New York Post. Irvin Giovanni Alfaro Lopez, 33 years old, faces allegations of sexual misconduct. He was charged with molesting 4 young girls while serving as a teacher at a church just outside of Washington, D.C. Alfaro Lopez's criminal history and immigration status have ignited a fiery debate on policy and protection, according to the New York Post. Authorities have levied 25 counts of sexual misconduct against Alfaro Lopez, with accusations dating all the way back to 2014, now 10 years ago. The alleged incidents occurred at the Elam Mission Christiana Church in Maryland, where Alfaro Lopez worked as an instructor and educational coordinator. Reports suggest that the abuse took place during prayer times, exploiting the victim's multiple vulnerability, according to the Post. Alfaro Lopez's problems with U.S. immigration and customs enforcement make his situation more complex, the New York Times has said. He first entered the U.S. without permission. He was deported in 2015 and 2020, but he came back illegally each time. After his latest arrest, he's being held without bond. ICE plans to take him into custody after his trial if he's convicted. Oh, thank you for that, Biden administration. Glad you got around to it. The Montgomery County Police Department faced strong criticism for letting Alfaro Lopez go in August of 2023. That'd be this past year, even though ICE wanted to detain him. Darius Reeves, the ERO Baltimore Field Office Director, expressed frustration over the situation. Quote, "This is a perfect example of the level of criminality when folks are recycled back into communities and jurisdictions, are not honoring our detainers. Very tragic story here," he said in a statement to Fox 5. Counties cannot continuously recycle gang members with guns, child molesters, rapists, accessory to murders. You cannot continuously allow this to happen. Please stop recycling these egregious offenders back into your communities. And to not honor an ICE detainer, in my opinion, is an obstruction of federal law enforcement efforts. Well, of course. Of course it is. Isn't it interesting, the juxtaposition? You have a place like Montgomery County, which is letting the child molesters go free. And the feds, to the extent that are any in the government who want to protect them, are saying, please stop doing that. And then meanwhile, Texas is saying, no. You illegally immigrate, you come here illegally, we're capturing you, we're deporting you. This is our state. You've crossed into our border. We will enforce the laws. Federal, state, whatever we have to do, we protect our state. In fact, we have the constitutional right to thwart an invasion. And what do the feds do in that case? I'm sure there are some members of ICE who are supportive of Texas. I'm confident that the Border Patrol is. But the Biden administration, they're opposed. So everywhere the left is involved, they're for chaos. Releasing child molesters and stopping border enforcement. It's disgraceful. It needs to stop. Big win for Texas today. I hope it yields good things. It's 3:22 now. All right, in the midst of all this chaos, Peter Navarro today reporting to prison. The Biden administration, once again, throwing one of its political opponents behind bars. Peter Navarro was the trade advisor to Donald Trump. And now Biden is throwing Donald Trump's trade advisor into prison. Remember what they claim is that he refused to go in and testify to the very illegitimate January 6th committee. He said, I've got executive privilege here. This involves the president of the United States and his thoughts and my advice to him. Sorry, I'm not going to be able to help. This is executive privilege. And they said, no, you're in contempt of Congress, they said, because you're not going to talk to Nancy Pelosi's made-up committee. And they've litigated this. They've gone through the courts, and now they say he's got to serve 4 months in prison as a result. He reported to prison today, and this is what he had to say about it.
They can put me in prison. They can put you in prison. Make no mistake about that. And make no mistake about this. They are coming after Donald Trump with the same tactics, tools, and strategies they used to put me over there today, okay? Think about this. Stripped of all defenses before a jury trial. That's going to happen to him. Democrats in all the jurisdictions he's in. Fani Willis in Atlanta. The guy in Manhattan, Bragg. And then, of course, Jack Smith at the Department of Injustice, as we like to call it on my side of the fence. So I'm pissed. That's what I'm feeling right now. But I'm also afraid of only one thing. I'm afraid for this country.
That's Peter Navarro today, just before he went into a jail cell. We'll keep covering it. Will Chamberlain joins us next. They're trying to do that to Trump. Will's got some thoughts on that subject. Hey, good afternoon. 3:35 now. News Talk 105.9 WMAL, where we're making sense of the news. Coming up, 4 o'clock from Hot Air, David Strom talks to us. We'll talk bloodbaths with him. He's got some tips for you. Julie Kelly will be coming up at 4:30. A lot to get into with Julie. She's been following all of these cases against Trump really closely. Also, the Peter Navarro situation, as Peter heads to prison today, sent there by the Biden administration. And then Dr. Stanley Goldfarb will be joining us at 5 o'clock alongside Congressman Greg Murphy. They talk to us about protecting the nation's doctors and the medical industry. You can join us at 888-630-9625, 888-630-WMAL. The case of big fat Fani Willis has, of course, captivated us. Down in Georgia, this is the Fulton County District Attorney who's trying to throw Trump in prison because she says he tried to steal the 2020 election. She's very mad about that. But then, of course, we saw weeks of court proceedings play out where it was put to the public, put to the court that, hey, actually, she should be disqualified because she's got a massive conflict of interest. She's been sleeping with her subordinate. In fact, kind of looks like she hired her lover and then paid him a ton of money and then flew around the planet on all that money she was giving him from the taxpayers. The judge deciding that he wanted to split the baby here and said, well, if your boyfriend quits, you can keep pursuing Trump. And that brings us to today. Will Chamberlain's here. He's the senior counsel at the Internet Accountability Project and the Article 3 Project, and he joins us now. Will, good to have you with us, sir.
Yeah, good to be with you.
You say that, well, it can't just end with Scott McAfee, the judge down there, letting this case continue. What should happen next?
Well, I mean, it's as simple as, it's time for the state of Georgia to wake up. In particular, I'm talking about Brian Kemp and Attorney General Chris Carr. Fani Willis perjured herself very obviously in court. She said that her relationship with her subordinate Nathan Wade didn't begin until late 2021, when there's a pile of evidence saying that it began as early as 2019, including her former landlord, a very disinterested witness, text messages from Terrence Bradley, and cell phone evidence that shows that Mr. Wade was at her dwelling repeatedly in the early morning hours prior to the date that they say their relationship started. They lied because they didn't want to be disqualified off the case. They thought that if it came out that she had hired her then beau to be a special prosecutor and paid him a bunch of money on an hourly rate, which is very rare among prosecutors, they thought Judge McAfee would disqualify her, and so they lied. But lying under oath is a crime, and so she should be prosecuted. She should also be disbarred. She violated a number of different ethical rules. I mean, obviously, you can't perjure yourself. There's a distinct ethical rule about candor to the court. You're not allowed to lie or mislead the judge in a court of law as a lawyer. There's also the fact that she has unique duties as a prosecutor to not, speak out of turn. There's an obligation not to say things in public that heighten public condemnation of the accused. She did that when she accused Michael Roman and his lawyer Ashley Merchant of playing the race card. It's a very straightforward violation of Georgia's rules of professional conduct for lawyers.
Yes.
So disbarred and prosecuted.
And
Judge
McAfee scolded her for those public remarks and did say that she was implying that it was the defendants who were being racist towards her for scrutinizing her in a way that they're entitled to. But on this question of her committing perjury before the court, Scott McAfee kind of danced away from that when he wrote his opinion. He suggested that it was possible, it was hard to find them credible, but he couldn't come up with a conclusive finding here. What did you think of Judge McAfee's posture towards what seemed to the rest of us to be obvious lies?
I mean, I think you've nailed it. He didn't want to say that the elected district attorney of Fulton County lied under oath. And you could tell if you were watching the hearings, he was a little bit worried about the longer-term consequences of that, not just for him and his own political ambitions, but for all the other prosecutions that are going on, right? Like her name is appearing on every criminal prosecution. She's ultimately responsible for every person that goes to jail in the entire Atlanta metro area within Fulton County. That's a lot of people and a lot of court proceedings that would be disrupted by the fact that it turns out the DA is a liar. But the DA is a liar, and it's his job not to, at a certain point, like his job is to do justice. And in this case, what Fani Willis and her beau were trying to do was deceive the court in the service of denying the Trump defendants due process. Every defendant in this case is entitled to a disinterested prosecutor, and that they would deceive the court and try and hide the evidence of their conflict and lie, totally unacceptable.
The one of the most cartoonish examples of what you're talking about is when Nathan Wade was talking about his divorce paperwork, where he constantly insisted on in sworn affidavits that, oh no, I wasn't stepping out on my wife. No, I'd never had a relationship with any other woman. No, it was denied over and over. And then when he was asked in court about that, he became really philosophical. He's like, well, technically, the way I thought about my marriage was it was over already. So therefore, I was answering honestly when I said no, I wasn't stepping out on my wife. I was like, dude, you're a lawyer. It was a legal question. Were you legally married or not? And the judge was like, that was ridiculous. That was the most ridiculous sequence of events I've ever seen.
Yeah, no, it was embarrassing. And I mean, it was a bizarre thing to try and do because, I mean, do you really think it's going to persuade the judge? If anything, it just, you're better off admitting exactly what you did. And the big irony here is the way that the judge viewed the actual conflict of interest, the law around that. He viewed it very narrowly. He was like, you have to prove continuing financial stake in the investigation on the behalf of the district attorney. So oddly enough, under that standard, they probably, that's the wrong standard to apply. But if they had just told the truth completely from start to finish and just admitted, oh yeah, we were in a relationship. Oh yeah, I hired my boyfriend. That probably wouldn't have met the threshold that Judge McAfee set. In fact, and so in the ironic thing is they've created all sorts of problems for themselves by lying when it actually really doesn't turn out to have been necessary. They could have just told the truth and fessed up.
Right. And the whole thing where she said, I paid him back constantly with cash is, again, quite obviously a lie. And it was a useful construct to offer some sort of excuse like, oh, yeah, everything was on the up and up. But a real district attorney who was really acting in an ethical way would have documented every single one of those reimbursements in order to make sure she had the record of it. So if she was ever asked or called on it, she'd be able to present that. She didn't have any of that. She's like, no, there's no paperwork to support it. You're just going to have to go with a trust me, bro explanation.
Yeah. I mean, I just worked for the state of Florida, right? And so I don't know how many of, there's probably some people in the audience who've worked for state governments before. You know that they tell you right off the bat, you don't get to take gifts from contractors with the state, right? People who do business with the state do not take gifts from them, period, and stop. And so she not only hired her beau as a contractor, she then accepted gifts from him routinely and never documented any of this. I mean, it's just, that actually is very flagrant. Now, whether that, it's actually beyond the questions that are in the case of like, is there a conflict, is there not? It's appalling behavior. It's ridiculous. And it should lead to her resigning and being disbarred.
Well, it also leads to more questions about what else is she being dishonest about. So you mentioned, obviously, every other case that the Fulton County District Attorney has ever taken up. If I'm a defendant in any of those cases, if I've been convicted in a case there, I'd be wanting to raise this as an issue. Wait a second, the DA is a liar? That kind of seems like a problem. The other piece is, to what extent was she a part of an active political conspiracy against Trump? We know that she's willing to be deceptive about the basics, about who she's paying, who she's sleeping with, and under what circumstances. So why wouldn't she conceal from us some of the big questions, like who's actually driving the Donald Trump prosecution in Fulton County, Georgia?
Right. Yeah. So she probably has answers to those questions. Now, I mean, you could never get her to say the truth. What she's made clear is she doesn't care about being under oath. Like, it's no different than just being out with her friends.
Yes.
Being under oath in terms of like what she's willing to say truthfully. And you'd think a lawyer would be different than that. And actually, it's really important that lawyers be different than that, because courts can't do justice if they don't have a good sense of what the truth is.
Yes.
That's one of the reasons judges get so angry when litigants or just witnesses or dissemble and lie. They get furious because they can't do their job.
Now, I want to take us back to where we started, which is your suggestion today. You are calling on the governor of Georgia, Brian Kemp, and his attorney general, Chris Carr, to charge both Nathan Wade and Fani Willis with perjury. Do you expect that that's something they will do?
No, I don't think so. I doubt it. I've been very unimpressed. They've been seemingly happy to take a back seat. I feel like there's some lingering resentment towards Donald Trump from what happened during 2020 among Georgia's the top level of Georgia state government.
Yep.
But they need to get over that. This isn't just about Trump. It's about all the other defendants. And it's about the legitimacy and the seriousness that people are going to look at Georgia going forward. I mean, they're letting Fani Willis turn the state of Georgia into a joke, an embarrassment. Lying under oath in front of the entire country in a way that's just blatantly obvious. I mean, it makes their judicial system seem silly, and it's on them. I mean, they can't. I know they have some limitations in terms of pardon power and things like that. Like the Georgia governor, for example, doesn't have the pardon power in the way that governors in other states do. But what they do have, certainly, what the Attorney General does have, is the authority to prosecute crimes committed in the state of Georgia. And, wow, I mean, Fani Willis straightforwardly committed perjury in ways that are provable and obvious to everybody just based on the evidence revealed in that court hearing.
Yes, but without the judge saying that. So the judge, like I said before, Judge McAfee went out of his way to kind of conceal that he thought that she had committed perjury. Do you think that hurts the ability of the attorney general to launch that prosecution? He's like, look, the judge hasn't even said that, and it was in his courtroom.
Not really. I mean, this is for objective observers can evaluate the testimony and compare it to the facts that were adduced on the ground, right? Like whatever the judge thinks of that, whether that judge thinks it's about perjury, he wasn't charged with answering that particular question, whether the elements of perjury were satisfied and whether a crime was committed.
Right.
Maybe he'll later be charged with that, and we'll see what he thinks. But I think at a minimum, there's probable cause. I mean, even in the opinion, he says there are reasonable questions about the truthfulness of the district attorney's testimony. That's sufficient for probable cause for at least an indictment and an investigation. I mean, ultimately, if Fani Willis can prove that all her bizarre and ridiculous stories were in fact true, good for her. But she should be indicted and charged and made to show up in a court of law and prove her point. Yeah.
I mean, you'd be treating her better than she's treating Trump based on that standard for sure. It's
correct.
Kind of amazing. Lastly, the Trump side, I see all of his co-defendants are now requesting a review of Judge McAfee's decision to not disqualify Fani Willis from this Georgia case. Does that mean there's still some sort of outside chance she could be disqualified? What are we looking at here?
Yeah, I think that's the way to think about it. It's not. I wouldn't say it's not like absurdly unlikely, but it's not the probable outcome. If you were a betting man, you'd say to put the odds somewhere around 25% or maybe 15 to 25%, something like that. The reason being that it's not that. I mean, eventually, eventually when this goes up at appeal, I think the appellate court will certainly rule that she should have been disqualified. The question is whether they can appeal that question now before the trial has happened. That's what's called an interlocutory appeal. And that not only requires the judge the trial judge to agree that the issue should go up on appeal right now, but also the appellate court needs to agree that it's an issue of such importance to take it right away on appeal before the rest of the proceedings go forward. So, I mean, there's two different entities, and it's really within both of their discretion to simply say, no, thank you. we want to go forward. And so you basically just have to bet that they both, what has to happen is both of those entities have to decide this is of such importance that it should be taken. Now, I think it should be taken from their perspective, just on the grounds that if they don't take this, don't resolve this DQ issue right now, and they go to trial and get all these convictions, and then it gets reversed on appeal, well, then all the results of the trial will be thrown out. So it's a giant waste of time and resources. So I think, getting this right, there's just really good prudential reasons that this should go up on appeal right now and get fixed.
Cool. All right. Will Chamberlain, again, senior counsel at the Internet Accountability Project and the Article 3 Project, gives a great column in the Federalist today on this issue. Always appreciate your time, sir. Thank you very much. Okay, I'm just convinced, and there are some exceptions. This is not a blanket statement, but it's pretty close. If you live in Loudoun County, your government hates you. They hate you. At least the school board does. They hate you. This week, we get the news that the Loudoun County School Board has voted to turn off the cameras completely during the public comment period. No more allowing the public to see the person who's raising their concerns. A 6-3 vote this past week. I'm quoting from ABC 7 now. Loudoun County School Board member Sumera Rashid saying, quote, "I'm trying to avoid a Jerry Springer show type of episode. So for that reason, I can't support that the camera be on the speaker, but mainly it's the safety issue." School Board Chairwoman Melinda Mansfield made the motion to turn off the camera during public comment. Quote, "I'm not interested in this being political grandstanding," which has been happening a lot lately. And I think that takes away from the work of the school board, said the woman called Mansfield. All of the Democratic-endorsed school board members voted to turn off the camera during public comment. All of the Democrats, Mansfield, Rashid, Arben Estrefi, Linda Deans, Ann Donahue, and April Chandler. Independent school board member Lauren Chernoff and Republican-endorsed school board members Carrie LaBelle and Deanna Griffiths voted against turning the cameras off. They would like the public to see what is happening inside of the school board meetings. So, who are the fascists? Who are the censors? Who are the ones who are trying to block you from having info? That would be the Democrats. Everyone else said, keep the cameras on, baby. What's the problem? The school board's decision came after some members of Loudoun County's Muslim, Christian, and Hindu communities visited the school board on February 27th and spoke out during public comment about Loudoun County Public Schools policy that allows students to choose whatever bathroom or locker room they feel like based on an invented sense of gender identity. I'm not even quoting from ABC 7 anymore. This is Vince Coglianese for you right off the top. But this is what the point is. They go there, you get Hindu parents, Christian parents, Muslim parents going, no boys in the girls' room. That's insane. And now the school board says, how about this comment period not be videoed anymore? How about we stop putting the camera on these parents? Apparently, Governor Glenn Youngkin blasted them for this. Here's Nick Minnock sharing this today on the social media.
Fights and undermines the work of the school board and the transparency of the school board.
This is stunning. To be clear, this is the same school board in Loudoun County that tried to hide girls being sexually assaulted in bathrooms.
Yes.
Didn't want to tell parents
Scumbags.
when there were overdoses at their schools.
Total jerks.
And now has the completely misguided view that turning off cameras increases transparency.
What a bunch of schmucks. And so there's that. And then additionally, Nick Minnock is now reporting that the thought process is leading to this. This Thursday at 2 p.m., Loudoun County School Board members will be meeting to discuss their public comment participation policy. Multiple sources have told Nick that some Loudoun County School Board members are discussing limiting the public comment period to once every 3 months. One public comment per quarter. They hate democracy. They hate the voice of the voters. They hate parents. They hate your involvement. And so for that reason, we hate them. They earned it, unfortunately. David Strom joins us next. He's from Hot Air. We'll talk about how bloodbaths are definitely in the eye of the beholder.